All right, let's take you back now to one of our leading stories. The President of South Africa has 12 months to remedy the defect in the Executive Ethics Code. This as the Constitutional Court confirmed that the High Court in Pretoria's declaration that the code is inconsistent with the Constitution and invalid to the extent that it does not require the disclosure of donations made to internal political party campaigns. Now, let's discuss this further. We're now joined by political party funding researcher with MyVote Counts, Robyn Pasensie. Robyn, thank you so much again for joining us. I hope you can hear me this time. But just let's get your thoughts on the ruling. And perhaps, again, just remind us what is at the heart of this litigation.
Absolutely, yes. And thank you for having me on the show. And I can absolutely hear you clearly now. So sorry about the technical issues earlier. But it really is quite an important judgment that was brought down by the Constitutional Court earlier today. And really what is at the heart of this judgment is indicated on some of the earlier judgments, particularly with My Vote Counts, around this idea of access to information and disclosure of political funding information. So obviously we already have the PPFA, which speaks to the private funding donations for our political parties, but the PPFA is silent on the donations that happen within political parties or intra-political financing. And how this came sort of to light particularly was off the back of the CR17 presidential campaign within the ANC. And it came to light that obviously there are vast amounts of money being spent around members of political parties who are obviously campaigning for positions in their party and are obviously accepting donations into their campaigns in order to sustain this campaign that they are running for whatever position it is in their political party. And what we do have that governs the kind of disclosure of assets and wealth by the executive is what we call the Executive Ethics Code. And here members who are subject to this code have to clearly disclose when they receive any kind of gift, be it monetary or in kind or any other asset that may be pertinent here. And this is to stave off the possibility that these officials can be compromised. And what Amapungani did was, in bringing an application to the High Court in Pretoria, is that they were saying that the Executive Ethics Code was unconstitutional to the extent that it did not require members who are subject to this code to actually disclose when they receive financial or other contributions to their campaigns for positions in their parties.
Now, given that the judgment itself does not apply retrospectively, just unpack what the bearing does, on either the controversial CR17 campaign or even the ANC party's, December elective conference, if at all?
Well, unfortunately, as significant as this win is, because it cannot be applied retrospectively, it obviously means that anything before the date of 20 September 2023, because they'll be given 12 months to amend the code to bring it up to scratch, basically. Anything before that time is not under review. So even though what it started off, partly this journey to get to this judgment was in fact CR17 and the allegations made there, we will not actually be able to use the Executive Ethics Code when it is brought up to scratch to actually inquire about that. And in fact, we will not also be able to use it when we look back at the upcoming conference in December of the ANC. So on that score, unfortunately, there is a loss. However, despite that, we should not be viewing this win as being any less significant. It means that going forward, the precedent will be that you have to disclose when it comes to your election campaigning within your party.
Remind us again why this particular, judgment and verdict is important, that, South Africans know who are donating to the political parties themselves, and they vote into power, the people that they vote into power, and of course what it means for transparency.
Well, both this judgment and the judgment that the ConCourt actually made in terms of My Vote Counts and the application that we have brought forward with the promotion of the Access to Information Act at the time, was that the ConCourt then, as it did now, very clearly made the point that there does exist a toxic relationship between money and politics when money is allowed the sort of unregulated, unfettered access to our political parties and to our politicians. And the point was that there was a precedent set with the My Vote Counts judgment in that we were now committing ourselves to transparency, to transparent negotiations, transparent actions when it comes to actually soliciting donations for a political party. And now with this judgment with Amabungani, this now also extends to members within the political party and how they source their donations for their campaigns and the positions in the party. This is significant for the ordinary person, for the voter, because now this is another level of access to information that we have that was previously unavailable to us. And what the ConCourt ruled, particularly with My Vote Counts, is that in the expression, in giving sort of rise to our right to vote, we need access to information. We have a right to ask questions around who funds our political parties and who in fact funds, particularly now in this case, our politicians, because we don't want a situation of corruption where our politicians, our political parties are beholden to private interests. And so this is really, I think, the ultimate significance of this kind of judgment when it comes to being able to see what our politics, what our politicians are actually doing.
Robyn, thank you so much for your time this afternoon. Really do appreciate your analysis. Robyn Pasensie there from My Vote Count.